Welcome to the 24th episode of Certum Group's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar from top law firms and companies and legal institutions around the country. On this program, we discuss the latest litigation trends and strategies across a wide spectrum of commercial litigation, especially class action litigation. I'm your host, Kevin Skrzalski. I'm a director with the litigation consulting firm Certum Group, where we specialize in working with businesses and their outside counsel to mitigate, cap, and transfer litigation outcome risk. Today, we're going to be discussing a very interesting topic. I love the creative title. I actually stole it from my guest, but it is going to be What's Cooking in Food and Beverage Class Action Litigation in 2024? And to do that, I have an expert in the field. Today, I am pleased to be joined by Tyler Young, a partner in the Minneapolis office of Faegre Drinker, where he defends food, beverage, and consumer packaged goods companies in consumer fraud class actions and complex litigation across the country. Tyler, Happy New Year. It's a pleasure to have you on the program.
Thank you for having me.
So now, Tyler, I know that you have been defending food and beverage companies, or perhaps we should call them consumer packaged goods companies now because the definition has broadened, for a number of years. And we just continue to see an increase in the proliferation of these types of cases. What is it that keeps driving so much litigation, and why haven't we created some ways to prevent it from just increasing year over year as we've been seeing for a number of years so far?
Yeah, I mean, you're absolutely right that the number of new claims does continue to just go up. And that's just looking at the claims that actually turn into filed complaints and not taking account of all of the claims that are resolved pre-suit. And from my personal experience, those are going up too. Why are they going up? I think we've had some one-off explanations. There are some extremely prolific attorneys. Spencer Sheehan out of New York, I have a docket alert for him, and I think it trips almost every business day of the year. So that does distort the data a little bit. But even if you take all of those filings out, we do see year over year the numbers going up. And I think there are a couple explanations for that. Probably the easiest is that when plaintiffs' counsel are evaluating class action litigation, some of the things they value are products that have significant sales, because ultimately their damages theories in almost all cases are going to be tied back to a price premium. And then they multiply that price premium by the number of products sold. Food products often have extremely high sales. Another thing that plaintiffs' lawyers value as they look at a claim is the ability to say that every consumer of the product was exposed to this allegedly misleading statement. And if you are talking about advertising that's in a magazine or on a billboard or a website, that's harder to do because many consumers could have just walked into the store and picked it up. When the statement is on the label itself, as almost all of these food and beverage class actions, it's the case in almost all of them, it's much easier for the plaintiff to say, look, every single consumer was exposed to this statement. So I think those combination of things make it a really attractive area for plaintiffs' lawyers to pursue. And then I suppose icing on the cake is we are seeing consumer perception and consumer preferences change and evolve, and people get interested in label statements that weren't really a thing 10 or 15 years ago. Now there's demand for some of those label statements. 15 years ago, if you told me that there would be food or beverage products making carbon neutral claims or things like that, I would have been extremely surprised, but that's the move that we are seeing. And so that drives interest for the plaintiff's bar as well.
No, I think you raise a really excellent point that many of the advertising litigation is against the largest manufacturers of consumer brands. And that's because, as you said, their products, like if you walk down the coffee aisle, the soda aisle, the suntan lotion, these are almost ubiquitous products that are in every single American's home. And so when you're looking at sales revenue times size of the class, they're targeting products made by companies that have large portfolios and potentially like significant payouts and damages. So you're right. But you also mentioned some new advertising, wording that you see on packages that we haven't seen before. And Faegre Drinker hosted a fantastic conference, class action litigation, food and beverage litigation a few months ago. You had done a go through program, which was the impetus for inviting you on my show. You identified the top 5 areas that we didn't really necessarily see before that we're now seeing now. Some that died, some that came back, and I think we're going to continue to see them for 2024. And I'd like to just go through a few of them. So let's start with one. It looks like there's these citric acid and these malic acid types of claims that are the basis of, it's like the new natural litigation. We're talking about all natural, 100% natural. And now it seems we're talking about no preservative or no artificial preservative. And in fact, by my count, we saw the number of cases filed in 2023 double from 2022. So why are we now seeing this? Is this the new natural that we're seeing and that we're going to see in 2024?
Yeah, I think it is. That's certainly the way we're thinking about it. I mean, anyone who has been in this area of law for long enough remembers that there was a time where the natural suits were just the star of the show in terms of food litigation. We've seen those lawsuits, the filing of those lawsuits, decrease over time. And I think part of that is there are just fewer targets to shoot at. Because of the litigation, I think a lot of companies have tightened up their labeling and taken all natural, 100% natural off a lot of their products simply because it was drawing litigation. But in addition to that, we have seen that, natural claims often made it past a motion to dismiss, but there's a big difference between making it past a motion to dismiss and taking a claim all the way to verdict. And we've seen that one of the things that was maybe a strength in natural claims at the pleading stage, you had a lot of judges saying, well, I don't know, this is ambiguous. It could mean this, it could mean that. Consumers could be deceived. Ended up being a limitation down the road when you get to class certification, because plaintiffs have encountered difficulty showing that consumers have a uniform understanding of that label statement. And thus, courts have said this isn't appropriate for class certification because we can't resolve this in one fell swoop that would apply to all consumers. I mean, we saw a good example of that just in the past couple of weeks in a Colgate case about Tom's toothpaste that was brought by Bursar and Fisher. And this was after, I think it's close to a decade of litigation. And the case fell apart at class certification. So I think you have enough of those happen, and the plaintiffs bar, they're rational economic actors, and they're going to say, I don't want to sink millions of dollars into pursuing working up a natural case if it's not going to pay off in the end. So I think there's been a shift to these no artificial preservatives, no preservatives claims for that reason, that I think it's easier to define just as a conceptual matter, what does it mean to say we've got no preservatives or we have no artificial preservatives, than it is to say, what does it mean to be natural?
Right.
So that's a little easier. I think there's also a situation where there are many products out there that have malic acid or citric acid in them and that have these label statements. It was a relatively common practice in the industry. I think this is one of those situations where people just never thought that this could be an issue, which does happen periodically.
Yeah.
And so I think there's a lot of targets to shoot at, and there's a perception that this is going to be an easier claim to take all the way through.
Yeah, I think you're absolutely right. That word was being used on labels, and then lawyers go to the marketing company and say, hey, remove that label. And then they put no preservative or just this or only that, or now it's pure. And It's this cat and mouse game of trying to effectively market your product so you can convey the correct message to the consumer public and have sales, versus the litigation and the plaintiff's bar that's always thinking of some new creative way to sue US-based companies. So
I always think about it as an arms race, right?
It's an arms race.
Yep.
I want to go through a couple more topics that I want to ask you how you combat that arms race. Let's move on to another popular area that is still, it's been discussed, it's been litigated a bit. It still is a little confusing for some folks who I speak with in the marketplace. That is the whole PFAS, the forever chemicals, and the heavy metals. For any of our listeners who would like a refresher on exactly what we mean by this, can you provide an overview of the basis of this PFAS heavy metal litigation and the difference between them?
Yep, I can. And I'll take it in reverse order. I'll take heavy metals first. So the heavy metals cases, we've seen them both class actions and some personal injury claims as well against a variety of food products, probably most prominently baby food products, but also chocolate and spices and dog food. And the claim here basically when we say heavy metals, we mean lead, mercury, arsenic, and cadmium. And the claim is usually based on laboratory testing that the food product contains some amount, usually in the low parts per billion, of one or more of those heavy metals. And the claim is, in a personal injury case, this actually harmed me. In a class action, I was exposed to this, and the presence of these heavy metals in your product makes some statement you made on your label about your product is healthful, natural, wholesome, pick your statement, whatever it is.
It devalues it, and then it's back to a price premium theory.
Exactly. We're back to the price premium.
Right.
So the thing that I think everyone should understand as they think about these heavy metals cases is that heavy metals are, I think when a lot of people hear this, they think, oh, in the manufacturing process, somewhere along the way, heavy metals are being added to the food product through some bad manufacturing process. That's not the situation. Heavy metals are ubiquitous in the earth's soil. And when you've got a food product that grows in the ground, it is almost inevitable that it will take up some amount of heavy metals. There are some crops that are much more likely to take up significant amount of heavy metals, others that are less likely to take up heavy metals, and it does vary where the crops are planted. But as a result, almost any produce you've consumed in your life probably had some amount of heavy metals.
Yeah.
The new thing we're seeing is that the limits of detection for testing for heavy metals have gotten much, much lower. And so you're able to detect, the level of a few parts per billion. So that's what's going on with heavy metal claims. I will just say before I move on to PFAS that these claims are being pursued actively. Mm-hmm. The heavy metals claims, they haven't been hugely successful thus far. We've seen a number of the class actions thrown out at the pleading stage, especially in the baby food arena, a lot of them thrown out basically on the theory that there's no injury here because you can't even say that the product you purchased had heavy metals in it, right? It's more of a categorical argument about the product. And you don't have anything to suggest that the level of heavy metals that you allege were in the product actually would cause any harm to you or anybody else.
There's no damages. I mean,
that's right.
If there could be a theory about maybe it's a medical monitoring case, but to your point, aren't these like elements in the periodic table? They exist naturally, not just in the soil, but I mean, you've heard the same from scientists and experts. They're in the atmosphere.
Absolutely.
They're in the clouds. They're in the rain. They generally are ubiquitous in the whole organic system that agricultural system that we operate in. Do you think that some of the public hysteria, because I remember when this happened, I had a friend of a family member post this big thing on Facebook, throw away your baby food. Like, do you think that the hysteria is going to die out and people will think about this rationally as perhaps major news networks report on this and these cases will go away, especially because they haven't been very successful? Or do you think they're going to continue? Or some other chemical they think of that they claim is dangerous?
Yeah, I think it's more likely that there's going to be a new chemical of concern du jour. I mean, the hysteria, I understand at some level why people became hysterical about it because a lot of reporting was pretty alarmist. And I think that's why a lot of plaintiffs' lawyers gravitate toward this sort of heavy metals, PFAS type of claim, because you step back to the first thing we talked about, that the number of these suits is just going up year after year. And I think judges have fatigue with these suits. Their dockets are getting absolutely flooded with these suits. And I think we are seeing a more robust application of the reasonable consumer test because of that.
Right. The defense. Yeah.
That's right. Now, if I'm a plaintiff's lawyer and I'm seeing that judges are more and more willing to throw out what I'm going to pejoratively call sort of the technical violation or the silly claim, right? I thought my vanilla ice cream cone was going to be made from 100% vanilla bean, even though it costs $1, right?
Yeah.
Instead, I think there's an impulse to premise claims on allegations that will grab some attention and say, oh, well, I've heard of lead, right?
Yeah.
We all know lead can be dangerous at certain levels.
Well, it's not going to tug at my heartstrings by a vanilla ice cream cone versus the food and feeding my baby.
That's right.
Yep. So you're going to get a much bigger public options. Yeah. Okay. Yep.
I think that's part of it. But to your question about is it going to die down, at some point, the litigation will die down a bit if it doesn't yield success. I mean, we saw that. I mean, I think of the heavy metals and the PFAS cases as sort of thus far being in the same tradition as the glyphosate cases, which got a lot of attention, but, didn't actually generate, on the class action side at least, generate that much. And I'll just briefly touch on the PFAS. It's similar but different. It's another, chemical of concern type of claim. These are, however, man-made substances. There are thousands of different PFAS chemicals. You see them most often in packaging or in like a liner in a food product, because one of the most common applications is they're a really great grease barrier, right? So if you've got a greasy food product and you want someone to be able to hold it, or popcorn bags, microwavable popcorn.
The bag that your dog food comes in, something like that. Exactly. I heard that's, right.
Yep.
Yeah.
Yep. So the science on what exactly is risky in PFAS, if anything, it continues to evolve. But I think one of the challenges that a lot of these suits are encountering now is that so many of them are premised on the allegation that, well, I tested the wrapper and it had PFAS. When
the wrapper, okay.
I don't eat the wrapper, right?
Right.
And your dog doesn't eat the bag that the dog food comes in, right? So,
excellent point. Yeah.
Yep. So the cases are going to get more interesting if and when there are claims about PFAS in the actual food or beverage product. I'm starting to see some of those. At least that's the way the allegations read. I mean, I think the testing is, as I understand it, much more difficult to do in sort of a solid food product. So I'm very curious to see how those allegations are going to be substantiated. But I think that's when those cases will present a more interesting question.
I think that's very interesting. Let's cover two more popular topics we saw in 2023 that we'll see in 2024, and then we'll talk about some defenses and how you counsel your client against trying to avoid some of these claims. So geographic origin claims and the recycling or the recyclability. Now, Certain Group, we provide settlement insurance and claims-made settlements that operates as a financial risk transfer vehicle for businesses. And we've worked on a few of these cases over the past year or two, and they're quite interesting. I mean, I think starting with geographic origin, I think these went away for a little bit, but then we saw a resurgence. Are we seeing a resurgence because the words on the label are so obvious? Like, if your X product wasn't made in this city or country, is that a pretty hard one to defend? And is that why we're seeing a sort of a resurgence in these types of cases?
I think it's a yes, and I think it's both that plaintiffs are being pretty systematic in looking for products that they can allege convey a geographic origin claim. And it's something that I think these are interesting cases to defend when they come in, because they are really fact specific, right? And they're about the confluence of words and images and flags and,
right.
the use of a foreign language, words in a foreign language on the label. I just think they're interesting fact patterns, and they're fun to talk to non-lawyers about and say, well, look at this food product. Do you think this means that this bag of tortilla chips was made in Mexico or not? So I do think they're interesting. I think there's also been, on the company side, we have seen companies having more of an interest in conveying something about where their product comes from, right? That it's not, let me say it this way. Consumers are showing that they value local products, authentic products, not necessarily wanting
exotic origins or something. Right?
Yeah. Exactly. Not necessarily wanting to have the same bag of Cheetos that they would get anywhere, right? Not to pick on Cheetos. So I think there has been more interest in making label statements that, if they don't convey a geographic origin, claim could at least be characterized that way. So I think it's happening at both levels. I mean, I do think, I'll just say, we are seeing this really push to the extreme, where we're seeing some claims where it's truly just like the colors used, right? Like if you've got a Greek yogurt and it's got blue and white.
The flag color.
Right. You can say, well, that's the color of Greece, those two colors. So I think that's a bad claim and it's not going to fly, but I think it's a relatively easy claim for a plaintiff's lawyer to put together.
Yeah, that's pretty interesting. Let's also talk about recycling and recyclability. I mean, I think you had mentioned, there's been a spike in like the aero litigation, like, What is, and here's the thing, it's not whether or not something is recyclable, it's whether or not all of it is recyclable, or a portion of it isn't recyclable, or a portion can't be recycled at this particular type of facility, or maybe there's a, special facility. I mean, what are we seeing in this? And is there a spike also based upon like developing regulations, or just the ongoing science behind what is recyclable and what isn't?
Yeah. So those are all good questions. This is absolutely has been and is going to remain a hot topic for years to come. To take one of your last questions first, I think we are seeing changes in evolution and litigation in this area based not just on the technology of what is recyclable, but on human and international behavior, right? I mean, it was one thing when there was a huge market in China for post-consumer cardboard and other material, and you could effectively recycle it by sending it to China and say, well, that's recycled. Now China has much less interest in buying up that sort of post-recycled content. So that puts things in a different perspective. You've also got the situation, it's a term that I heard really like, of people trying to do dream cycling, where they have something that is not even modestly recyclable or not even theoretically recyclable, but they toss it in with their recycling load, and it actually contaminates the rest of it and makes it so it can't be recyclable. So you have interesting things happening there. The litigation in this area that I think is probably most influential is there's a case in front of Judge Donato in California, which is still on the pleading stage. It's been going for some time, but it's against the three biggest producers of bottled water in the country. Mm. And the claim originally was pretty extreme, and the complaint was dismissed with leave to amend. The claim was basically, you can't say it's recyclable unless it is being recycled, unless it is always being recycled. Not just capable of being recycled, but in practice being recycled if you put it in the recycling bin. And I think we all probably know at some level that that's never going to be 100% the case. But in any event, the court said that's not how people understand the term recyclable. The plaintiffs sort of narrowed their claim quite a bit and then focused on the fact that allegedly the bottle cap and like the label that goes on a water bottle can't be recycled, at least not at every recycling facility. You need to have some specific equipment to recycle those. Mm-hmm. Judge Donato threw that complaint out too, saying, look, the label statements at issue here, recyclable, are being used in a way that is consistent with the FTC green guides, which recognize that, sort of incidental parts of a product can not be recyclable, like a cap. It uses a cap as an example, and you can still say that the product's recyclable. So good decisions from Judge Donato. He's given plaintiffs another chance to amend, which I believe they've done now. And I believe motion to dismiss briefing is underway yet again. So I'll be watching that case with great interest to see how it turns out. But we've also seen, so that's sort of the core, recyclable label statement litigation. But we've also seen really interesting litigation. For example, in, I think it's either New York or New Jersey, the Attorney General sued Pepsi and said, you need to be responsible for the single-use plastic pollution in the waterways. So that's fascinating. That's going to be very interesting to see how that plays out. And I won't go into all the detail, but there have also been some interesting decisions in this area in the DC Superior Court, mm-hmm. and it's now on appeal in the DC Court of Appeals. So this is an actively litigated area.
Yeah.
And I think the law is going to see some significant development this year.
It sounds to me from your answer, like if you had to pick almost like one of the four areas we discussed here today, that the environmental and the recyclability issue may be the biggest one, because there actually could be global impetus for bringing these claims and global impact. And of course, recycling is a huge movement. I don't think it's going anywhere. It continues to proliferate. But like you said, I think we'll both be watching a lot of these cases that are coming down the pike with a very keen eye.
Yeah, especially if you broaden it to ESG. I think you do that, it's very easy to say that's going to be the dominant trend in the coming year.
Yeah, definitely. Well, Tyler, I could keep talking, and I had a few more questions that I wanted to ask you, but we're kind of out of time. Perhaps we could do a second episode at some point in the future and come back on these. And if some of these predictions and these increasing trends continued, or what the new, to use a wonderful food and beverage cliche, what the flavor of the day will be mid-year or something like that. Yeah. Anyways, again, really, I want to thank you for being my guest, all your time, very valuable insights that you shared. Now, if anyone would like to contact you to discuss any of the topics that we cover here further, or I know you and Faegre do any events, is there anything you'd like to promote, or how could people get a hold of you?
Yep. Easiest way to find me is on the Faegre Drinker website. My email is tyler.young@faegredrinker.com. If you'd like to hear more content like this, we do a webinar series called Bite-Sized Legal, where we talk about anything and everything related to food and beverage law, both litigation, regulatory, compliance. And you can subscribe to those webinar series on our website.
And I would advise the audience to please do so. I am a subscriber to Bite-Sized Legal, and I stay informed with a lot of what is going on in the food and beverage litigation industry through the thought leadership that Faegre produces. And of course, as always, I would like to thank the audience for listening. If you'd like to hear more, you can follow us on Apple, Spotify, Stitcher, pretty much anywhere you listen to your favorite podcasts. And if you'd like to listen to a recording of today's program, or you would like to learn about any of the litigation funding or insurance programs that Certum Group provides, including class action settlement insurance or advertising litigation, you can visit our website at www.certumgroup.com. And you can always reach out to me directly at kevins@certumgroup.com. Thanks again, Tyler, and until next time.